Can you feel the Maduro vote against Guaidó vote?
Well, thank you for your patience, Mr. Varno. I think we're now ready. Yeah.
Yesterday I spent a little bit of time on the chronology, and I realised overnight that I should just have taken it a little bit further than I did. I think I told you, or perhaps this is where I stopped, that Miss Newman, Mr. Guaido's representative, resigned on the 1st of December 2020. On the 6th of December 2020, there were National Assembly elections in Venezuela. Mr. Guaidó did not take part in those elections, contending that they would not be free and fair elections. A new National Assembly was elected. My learned friends will want me, I know, to show you what HMG said about it, and that's at 1022 in the bundle, 1022. And obviously the Maduro board don't accept this characterization, but HMG's position was, you see from the bottom of that page, a Venezuelan National Assembly elections on 6th of December was neither free nor fair, didn't meet internationally accepted conditions, and there was a repeat using exactly the same wording that UK recognises the National Assembly democratically elected in 2015 and recognises Juan Guaidó as interim constitutional president of Venezuela. But the reason why I take you to that is it explains what I describe somewhere as a double de jure recognition. In this sense, Mr. Guaidó's claim is that the presidential elections were ineffective, and in his capacity as president of the National Assembly, he becomes president of Venezuela. His claim now is, although I'm not actually president of the National Assembly of Venezuela, because I didn't take part in the elections, I ought to be, and the National Assembly is somehow deemed to continue in existence, with me as the president of it, and therefore I am, or ought to be, president of Venezuela. So I hope double de jure isn't too glib. A characterization of what we say the claim now is. And just for completeness, if you go to 1251 in the electronic bundle, one can see the response of the European Union to that development, and that was to effectively withdraw its recognition of Mr. Guaidó. And you can see on 1251 that Mr. Guaidó is described in different terms. In the second paragraph, it says, in that context, the EU will maintain its engagement with all political and civil society actors striving to bring back democracy to Venezuela, including in particular Juan Guaidó and other representatives of the outgoing National Assembly, elected in 2015, which was the last free expression of Venezuelans in an electoral process. And there's Council of the European Union conclusions in similar form on 1254. And he's, I think sometimes, he's no longer treated by the EU as president of Venezuela. So, in a sense, that's by the by, because what you're concerned with is the HMG's recognition and the consequences of that. So, let me go back to, and perhaps round off, recognition before moving to the effects of recognition. But I wanted to, because HMG now submits, amongst other things, that the recognition was a recognition of competence to act as head of state, representing Venezuela on the international plane. Just wanted to show you what those roles of a head of state are. And if you could go to bundle 2, so I think the first supplementary bundle, at 1118. I hope I've got that right. No, that's not right. Just a minute.
We have a number of supplementary bundles. We were given shortly before the hearing what was called a new supplementary bundle, which superseded some earlier ones, I think.
Yes. Well,
1112.
1112.
In the bundle I'm looking at, this is the beginning of Lord Carnwath's judgment in...
Yes, that's not it. I'm looking for Watts. Yeah, legal position in international. 1311.
Yes.
Supplementary bundle 1311.
This is Sir Arthur Watts.
This is Sir Arthur Watts. I'm grateful to my learned friends and not sure what's gone wrong there. So I think you have a supplementary bundle and a second supplementary bundle, or should have.
Yes, what we have is a new supplementary bundle, and it's at page 1311 of that.
Okay. So this is an extract from Sir Arthur Watts's monograph on the legal position in international law of heads of state, heads of governments and foreign ministers. And he sets out at 1312 internationally relevant powers. He notes the unconcern with which international law regards the constitutional structures about states is matched to a large extent by its unconcern with the constitutional distribution of powers, because they are primarily matters of internal concern only to the states in question. But he says some specific powers are regularly vested in heads of state and are directly relevant for international law. And this is at 1313. He identifies 4 of them. They are the power to make war and peace at 1313, treaty-making power, also at 1313, and then at 1316, appointment and reception of diplomatic representatives, and fourthly, jus representationis omnimodi, which means a general quality possessed by heads of state, which is their general competence as the highest organ of their state to act for them in all aspects of their international attributability of their international acts to their states. And I did just want to go to page 1319, which is in a section on recognition. And in the penultimate paragraph on the page, he makes the point made really by all academic writers on recognition, that simplified talk of granting or refusing recognition conceals the real issue, which it always arises in recognition cases, which is that it concerns not just recognition, but rather recognition of whom and as what. And he's really, Latterpact and Talman all make the same point about recognition. You've got to be very careful with recognition of whom as what. And then finally on Watts, and I'm very sorry to say it's not in the same bundle, it's at page 163 of what I'm told is the second supplementary bundle. But it comes from the same monograph. You lordships have that, it's headed, no, chapter 3, heads of government.
Is this one that's called volume 2 supplementary bundle?
Yes, I think it is.
Right.
163.
The last page.
The last page of this file.
Yes. So it's from the same monograph, Sir Arthur Watts. And I think, in a sense, Hornbook law probably, but he says it's the state which in international law is the entity which enjoys legal personality as a subject of international law. And on the international plane, echoing words in the recognition statement, it is formally the state which acts. Supreme organ of the state is the head of state representing the sovereign majesty of the state. Its government, on the other hand, is the organ which exercises the executive authority of the state. And it is usually the government through which it, i.e. the state, acts, or which determines how it acts. Government's essentially a collective. And it says the head of government, usually they're not always known as the Prime Minister, is the head of this executive authority, rather than being symbolic of the state itself or representative of its international persona. Theoretical distinction between the two offices is usually maintained in state practice, where, for example, in the titles given, and then he says, where the head of state plays only a formal or constitutional role, the head of government may well in practice exercise the real power and authority within the state. The balance between the two officers, and indeed whether there need to be two officers rather than just one, which combines the role of both, as with the presidency of the USA, or one might say, like Venezuela, which under the Constitution combines the two roles, are, like the title given to the office of head of government, internal matters for each state to determine for itself on the basis of its own constitutional structure. When we looked at Article 226 of the Venezuelan Constitution, which is at bundle page 815, we saw that under Article 226, the President of the Republic is the head of state and of the national executive, in which latter capacity he directs the action of the government. And therefore, under the Venezuelan Constitution, it is the President in his capacity as head of the national executive in which he directs the action of the government. So I then want to just to remind ourselves of how the recognition is put by HMG. We looked at the shorter letter yesterday, but of course on the second invitation to the government to clarify or state its position, it has said rather more than it did on the first occasion. And so we must look at that. And if I can go to the Secretary of State's submissions, please, starting at page 2145. And these are submissions which I say make good the characterization of recognition in the single piece of paper which I gave you yesterday. So we can start at paragraph 35 on page 2145. And the Foreign Secretary says, the certificate meant what it said, and then 4 lines down, its clear meaning was that Mr. Guaidó was recognized by HMG as the head of state of Venezuela for all purposes for which a head of state can act. And you have seen the purposes for which a head of state can act, at least on the international plane, identified by Sir Arthur Watts. Second statement from HMG in bundle page 2147, paragraph 42, when they deal with the effect of the recognition, At paragraph 42, Mr. Guaidó and no other was the individual recognised by HMG as having authority to perform the functions of head of state of Venezuela. At paragraph 43, the certificate did not have to and did not make any statement about the extent to which any exercise of Mr. Guaidó's recognised constitutional authority could be or would be practically effective. Fourth point arises from paragraph 44, and really HMG is repeating perhaps the same point. The certificate was not purporting to make a statement of fact about the ability of the recognised head of state to govern Venezuela in all of the aspects that government involves. It did not imply nor need to imply that Mr. Guaidó had effective control on the ground, or that he was able to exercise the functions of government in fact. And then it's perhaps a slightly muddled sentence. It is not a precondition to the recognition of a head of state, or indeed a government, that he or she is in fact able to wield each and every aspect of government to the exclusion of any rival. The recognition is a recognition of competence to act as head of state, representing Venezuela on the international plane. And then, rather bizarrely, there is a reference to the Lord Privy Seal's explanation of the purpose of recognition, quoted at paragraph 5 above, but that is a statement in relation to recognition of governments. So, the recognition is a recognition of competence to act as head of state, representing Venezuela on the international plane. It follows, they go on, that where Mr. Guaidó can and does act in that capacity, HMG will treat him as entitled to do so. And then we ought to look at paragraph 45, which is the non-recognition, explanation of the non-recognition. And it's put in this way, paragraph 45. HMG evidently did not recognise Mr. Maduro as having competence to perform the functions of the head of state of Venezuela. Further down the same paragraph, necessarily implicit in the certificate is the non-recognition of Mr. Maduro as the constitutional head of state of Venezuela. He may be, quotes in, well, they're quoting me really, he may be in fact exercising power across a more or less broad sphere, as the Maduro board claims, but that is irrelevant. Well, that's what you'll have to decide, whether it's irrelevant. But the point is that insofar as there is a non-recognition or a statement of no longer being recognised, it is of him in his capacity, this is the last sentence of this paragraph, as the valid representative of the state of Venezuela on the international plane. So, those are the words, undoubtedly, we would suggest, extremely carefully chosen by the Secretary of State and his advisers. And you will search in vain for any recognition of Mr. Guaidó as head of government. You will search in vain for anything which gives you any indication of HMG's view of actual sovereignty in Venezuela. Now that is a profoundly important point, because we accept that this court is bound by the one voice doctrine to adopt and apply what HMG has said. But that means you must look extremely carefully at what HMG has said, what it has recognised, and that to which it does bind you. And we respectfully suggest that the very thing which the Guaidó board would have to demonstrate, that is to say, what we characterise as a de facto recognition of being in charge of the government, is plainly absent. And when you look carefully, it is noticeably absent. And that is why it has been so important to us what the nature of the recognition statement is. Because if HMG had purported to recognise Mr. Guaidó as actually exercising governmental control, we would have said that is frankly crazy, bears no relation to what is happening in Venezuela, where Mr. Guaidó has very little influence and absolutely no power, and then we would have been launching the nuclear option. But HMG hasn't said that, so we don't need to.
Well, you're running to get 2 points, but question of actual control on the ground, who's sitting in the President's office, is neither here nor there. But you're also making a point, as I understand it, that in appointing members of the bank, the President is exercising an executive function and not a head of state function.
Yes.
And you're arguing that the government, that HMG has not recognised him as the person with legal competence to exercise the executive function.
Right. Which reflects the reality.
Well, it doesn't, as far as appointing people to the bank is concerned. You don't have to be sitting in the President's office to do that. You can sign the necessary appointment.
Well, you can sign a piece of paper, but if the domestic legal system and the rest of the Central Bank of Venezuela pay no attention to it, it's waste paper.
No, it isn't. Not for us. If HMG tell us that that's the valid authority,
well,
we don't. It's not of interest to us what people in Venezuela are making of it.
Well, my lord, that depends, with respect, on whether you are purporting to decide what is effective in Venezuela or what is effective here. And that's why it is important that this is not some exercise of some supposed sort of extraterritorial jurisdiction by either Mr. Guaidó or by Mr. Maduro. It is an appointment in Venezuela to the board of a Venezuelan entity. Now,
we're finding what's legally valid in Venezuela, and if people don't take notice of that in Venezuela, that may be a matter of fact, but it's quite clear on common ground that the actual facts on the ground are not what we're concerned about.
Well, Lord, I don't accept that, and I'm going to come on very shortly to the effect of recognition and the Luther and Sagal line of cases, which in our submission says the opposite, and says that the courts are interested in what in fact happens, and not interested in questions of constitutional authority or fundamental lawfulness of the government. That is the point of those cases, we would suggest. I need to come on and develop.
If you are right that HMG's statement that you're taking us through from paragraph 42 onwards doesn't recognise Mr. Guaidó as having any executive power within, executive authority within Venezuela, that would block his claim. But in paragraph 41, we have a very clear statement from Her Majesty's government that from 4th February 2019, the UK no longer recognise Mr. Maduro as the Venezuelan head of state, whether de facto or de jure. So does that not block Mr. Maduro's claim?
Well, my Lord, no.
Why not?
Because he does not say to this court, in my capacity as head of state, I have appointed the board of the BCV. He says, in my capacity as head of the executive in Venezuela, I've appointed. Well, my Lord, in Venezuela, he will be acting, his appointments, which predate, most of them predate all of this, are nothing to do with acting as head of state on the international plane. They're one of many jobs of the president, qua head of the executive, qua head of government, of making an appointment. And again, surely HMG considered what they were going to say before they said it, and they haven't said they no longer recognise Mr. Maduro as head of government. And actually, even if they had said they no longer recognise him as head of government, that would still not preclude the Drake and Somalia inquiry. Because the mere fact that someone is not recognised is not determinative. There would have to be a countervailing express recognition of someone else as head of government. And that is the thing which HMG cannot, quite properly, cannot bring itself to say. So, Lords, we say that carefully chosen words, and I don't think I'm cherry-picking, the carefully chosen words of the Secretary of State are deliberate, careful, limited, and they are not enough for the Guaidó board to achieve what it wants to achieve. But that takes me on to the next section of the submissions. However, before I get there, I just need to deal briefly with what is said against the Court of Appeal in its approach to the meaning of the then much more constrained material on recognition. That's obviously the point which Mr. Otley developed yesterday, criticising the Court of Appeal's approach. And he identified those criticisms of the Court of Appeal at paragraph 13 of the Guaidó board's case. And he very helpfully identified 4 alleged errors. So I should tell you what I say about those, but
You accept that HMG has recognised Mr. Guaidó as president?
No, as president qua head of state.
Well, what they say is as president.
Well, they say slightly different things at different times. Right. The only court determination has been that he is recognised as president qua head of state, and the Guaidó board did not appeal against that.
Now, these appointments are made pursuant to Article 236 of the Constitution. Is that correct?
No, the appointments, the Guaidó appointments, yes, are purportedly made under the transition statute and only under the transition statute. And I should say transition statute so-called, because of course we don't accept it is a statute.
Well, is that right? I'm looking at...
Well, it's Guaidó board's case, my lord.
something of the Constitution, which we didn't seem to have, but I think I was looking at the actual appointments.
Well, 854 and 875.
I beg your pardon, page 8?
854 and 875, they're the relevant appointments, aren't they? The first is of the Attorney General, 854.
Yes.
Yes.
And then 875 is the appointment of the board representatives. Both refer to powers under Article 236.
233 and 333. That 333 is the one we don't have.
Well, we can certainly search for those.
It says pursuant to Article 233, 236, all right?
Yes.
Article 236 is 817.
Yes.
Section 2, the President of the Republic. These are attributions and duties of the President. And look to the left, it says Head of State Powers. And it's pursuant to Article 236, 1, 2, and I think 11 that these appointments are purportedly made. So they're being purported to be made by the President. Why not? And HMG has recognised Guaidó as the President.
Well, it has recognised him as President qua Head of State. It's made that crystal clear in the submissions it's made to this court.
This says he's a Head of State Powers.
I would have to. I'm not sure of the status of the marginal notes, but Article 236 simply gives all of these as attributions and duties of the President.
Yeah, the President.
And therefore it contains both classic head of government powers and classic head of state powers. The classic head of state powers are Article 2364. The classic head of government power is Article 2362. Excuse me. Yes, and specific powers, Mr. Sarushi reminds me, if you go to 819, at the end of this, any other the President has any other powers vested in the President under this Constitution and law. And that is the basis, I think, on which it is said by the Guaidó board that the specific power granted by the transition statute is conferred. Okay. We will check, but I'm told the marginal comments are not part of the text of the Constitution as such. But we better check that, because I understand, my lord.
I understand the Guaidó case. It is that these appointments were made as President, and the recognition is of Mr. Guaidó as President.
They say they were made qua President for the purposes of the Act of State doctrine. They say Mr. Guaidó made these appointments. They say he did not have power simply by virtue of being President, but his power arose under the transition statute. That's why I took you carefully yesterday to the express setting out of the way in which the power is said to arise, that it's not a power arising ipso facto from being President, not a matter of presidential fiat. It must depend on the conference, on the Guaidó board's case, conference of power. And the Maduro board position is the same, because there's a statute dealing with the BCV, which gives power to the President to appoint to the BCV. So there's an equivalence, but the question is the transition statute effective, or is the BCV statute effective? But can I just go back to dealing with the criticism of the Court of Appeal? But I preface it by saying this: it is, in a sense, and to no disrespect to anybody, all rather passé. Because the Court of Appeal was dealing with the government's first attempt to explain for the benefit of the court the recognition it had made. And we are now dealing with the government's second attempt to explain for the court the significance of the recognition it made. So in that sense, it is all rather passé, and you are sitting in that sense as a court of first instance. But subject to that, and in case it matters, given that HMG's position plainly does eschew any statement as to actual power, we would say that the Court of Appeal were plainly correct on the basis of what they had, and at their paragraph 122, to say there was no recognition of Mr. Guaidó as president qua head of government de facto. And as soon as you've got there, you know you have to construe the statement very carefully. They were right to do that. They were right to look at its context, and the context which they took into account can surely not be characterized as immaterial context if the statement is not unequivocal on its face. So there was nothing wrong with the Court of Appeal's approach, but as I say, it is essentially passé, and it is actually easier for you to resolve this case than it was for the Court of Appeal. And it's easier for you because of the Secretary of State's intervention. So can I move away from recognition as such to the question of the consequences of recognition? And this is ground 2. The question really is, what difference does any of this make? And I hope your lordships will have in mind that 2-by-2 grid, because as we approach the question of consequences, there are 2 things you will need to decide first. Firstly, am I right in my submission that this is what I characterize as a de jure rather than de facto recognition? That's question number 1. But separately from that, and I stress separately and independently from that, question number 2, has there been a recognition of Mr. Guaidó as head of government? And I say there's a very simple answer to that, which is that there hasn't been, and that you would be departing from the one-voice doctrine were you to hold that there were, because HMG has been so clear and unequivocal about that point. So I say you start with 2 features, but you must at least start with the one feature that there's been no recognition qua head of government. So what difference does any of it make? We must remember the BCV is the Central Bank of Venezuela. It is a creature of Venezuelan law. The BCV statute, for your note, it's Bundle 820, controls its operation. And in the normal case, it would be trite to say that in order to determine the effectiveness of an appointment to a foreign incorporated body, you ask that question under Venezuelan law, and you defer to the courts of Venezuela to see what their answer is. That would be the normal position, and I think that must be uncontentious. And we say, therefore, what is important in this case is sovereignty. Really the fundamental point with which I started yesterday. Can we look at what the Court of Appeal said in Brace, which is also something I showed you some of yesterday. So it's in the bundle at 2852. We looked We looked yesterday at paragraph 43, but perhaps we could pick it up at paragraph 67. I think I can pick it up 6 lines down. Unlike HMG, the court does not recognise or refuse to recognise foreign governments as an exercise in itself, but considers the question of the status of such governments in cases where the issue arises, because it is asked to decide the private rights and obligations of the parties before it. And the court accepts the sovereign status of a state or government, or refuses to do so, whenever the status of sovereignty so accepted or refused has consequences for the private rights of the party. It is misleading to talk of the court itself as according or refusing recognition or having that purpose. What it is doing is making a determination of the sovereign status of the foreign government as part of its reasoning in the case, whether with or without, this is a case without, the assistance of recognition of a government, in brackets, plainly, by HMG. Where there is recognition or non-recognition by HMG, and it must be of a government, because that's what we're interested in, it settles the question of whether the sovereign status for the purpose of the task, of the sovereign status for the purpose of the task on which the court is engaged, which is to apply that status to the working out of the rights of the parties. Now, can I just pause there and say this? Supposing HMG's present policy were as it was in the 1950s, where recognition of governments was made in accordance with the dictates of international law, and the question was not one of lawfulness, constitutionality, but of effective control. If that were the position, HMG would have assisted this court by recognizing the Maduro government, notwithstanding the fact that it disapproves of it, it heartily disapproves of it. It considers it illegitimate. But under its old recognition policy, it would have recognized. And in a sense, that highlights the embarrassment to HMG, which caused the old recognition policy to be swept away. And we make no criticism of any of that. That is all the matter for HMG. But it is, we would suggest, ironic that if the old policy existed, this would be a very easy case in which there would have been recognition of the effective government. And what has happened is the whole approach to recognition has been turned on its head, so that instead of recognizing the actuality with no sense of approval or disapproval, we've moved through no recognition statements to something completely different, where recognition is used as a foreign policy lever. And that's explicitly what happened in this case. When in the cases have you ever seen an ultimatum in relation to recognition? And that's how it's put by the Guaidó board. There was an ultimatum of recognition in this case. It was used as a threat to try to persuade Mr. Maduro, because he was in control, to do something. Now, we're not saying that that is improper, but we are saying you must recognize it, if that's the right word to use, you must recognize it for what it is, and therefore analyze very carefully what the consequences of it are. The question perhaps resolves to the question which my Lord Legate raised yesterday. Are we interested in facts on the ground, boots on the ground, tanks in the street, whatever it is? Or are we interested in constitutional or constitutionality or lawfulness? And we say that the answer to that emerges crystal clear from the trio of cases spanning 20 years, Luther and Segor, Bank of Ethiopia, and Banco de Bilbao. Now, I'm going to take these quite quickly, because of time. Luther and Segor is 2679. And the headnote says, obviously Court of Appeal decision, and it's one of the tail end of the Russian cases, the courts of this country will not inquire into the validity of the acts of a foreign government which has been recognised by the government of this country. In this respect, it's all one, whether the foreign government has been recognised as government de jure or de facto. Well, but then the ratio is put that the government of this country had recognised the Soviet government as the de facto government of Russia, existing at a date before the decree of June 1918, that therefore the validity of that decree and the sale of wood to the defendants could not be impugned. In other words, when the critical expropriatory decree was made, the government which made it was recognised as being de facto government, not recognised as having constitutional authority in a historical sense to do so, but recognised as actually wielding power. And if we go to internal 541, which is 2688, you can see at the top of the page 541, that, as Sir James told you yesterday, this was a case where another letter came in from the government, and you see at the top, I'm to inform you HMG recognise the Soviet government as the de facto government of Russia. Letter of April 22nd in reply to a request for information whether HMG recognised the provisional government of Russia in the period of its duration, and he sets out the answer. And so then Lord Justice Banks goes on, under these circumstances, the whole aspect of the case is changed. It becomes necessary to consider matters which are not material below. The first is a question of law of very considerable importance, namely, what is the effect of the recognition by HMG in April 1921 of the Soviet government as the de facto government of Russia upon the past acts of that government, and how far back, if at all, does that recognition extend? Now, that issue of retrospectivity of recognition was a very live issue in the 1920s, and when later on in the context of Act of State we look at the Princess Olga Paley case, I'm going to suggest to you that actually that's the issue, that's the turning issue of the third limb of the decision in Princess Olga Paley, is it's a retrospectivity of recognition case, not properly speaking an Act of State case. But here the question was retrospectivity of recognition, and at page 543, that's electronic bundle 2690, having set out the distinction, what we've labelled the Luther and Segor distinction between de facto and de jure, which you see in the middle of the page. A de jure government is one which, in the opinion of the person using the phrase, ought to possess the powers of sovereignty. That at the time it may be deprived of them. A de facto government is one which is really in possession of them, although the possession may be wrongful or precarious, that boots on the ground point. For some purposes, he says, no doubt a distinction can be drawn, but for the present purpose, in my opinion, no distinction can be drawn. The government of this country, having to use the language just quoted, recognised the Soviet government as the government really in possession of the powers of sovereignty in Russia. The acts of that government must be treated by the courts of this country with all the respect due to the acts of a duly recognised foreign sovereign state. Now, Venezuela is a a recognised foreign sovereign state, and the question, we say, is what is its government? Not who does HMG consider entitled to represent it on the international plane. And then at 2693, Lord Justice Banks, internal page 546, about 2 inches down, even if it was open to the courts of this country to consider the morality or justice of the decree of June 1918, I do not see how the courts could treat this particular decree otherwise than as the expression by the de facto government of a civilized country of a policy which it considered to be in the best interests of that country. It must be quite immaterial for present purposes that the same views are not entertained by the government of this country, are repudiated by the vast majority of its citizens, and are not recognised by our laws. So that's, we could look at more of it, but I don't think it's time. That's Luther and Sagal. Bank of Ethiopia and National Bank of Egypt is 2191. 2191. I hope. So this is Ethiopia and the flight of Haile Selassie. And if we go to 2196, there's an important point to hold on to here. Just in terms of chronology, Justice Coulson sets out that on May the 9th, 1936, the Italian government issued an annexation proclamation. Marshal Badoglio on May the 9th was appointed Governor-General and Viceroy as representing the King of Italy. And from that date, it appears as a fact from the evidence before me that the Italian government, through its officers, exercised effective governmental control over Addis Ababa, the siège social, or place of incorporation, I think that means, of the bank, and over a gradually increasing tract of Ethiopian territory. In the middle of December 1936, at which date the territory under Italian control seems to have covered the whole of the portion of Ethiopian territory in which any activities of the bank had ever been carried on, HMG, as I am authoritatively informed, recognized the Italian government as being, in fact, de facto, the government of the area then under Italian control. The effect of that communication is that I am bound to treat the acts of the government which was so recognized as acts which cannot be impugned on the ground that it was not the rightful but a usurping government. So this is exactly my Lord Legate's point. And he says that follows from the decision of the Court of Appeal in Luther and Sagal. And he says, my last observation applies not only to acts done after the date when his HMG recognized the Italian government as the de facto government, but also to any acts of that government done at any time at which, on the facts proved before me, they were in fact the government. So if you've got a period in relation to which there is no recognition, you decide the facts. It relates to any acts of the government done at any time at which, on the facts proved before me, they were in fact the government, though not yet recognized as such by His Majesty. So in a sense, long before Drake and Somalia, Mr. Justice Clawson was saying, well, in the absence of recognition, I'm going to have to decide for myself. Because the principle, being a principle of sovereignty and of de facto control, is a question about governments. So the third in the trilogy is Banco de Bilbao and Sancha from 1938, 2169. Decision of the Court of Appeal, and on facts not a million miles away from ours, because it was about who was appointed to the board of directors of a bank, and indeed a bank of issue. And the bank was incorporated in the very north of Spain, in Bilbao, in the Basque country. So if we can go to 2187, the bottom of the page, and I should say that the judgment is delivered by Lord Justice Clawson, but one can see at 2184 that Lord Justice Greer, McKinnon and Clawson were agreed, and so Lord Justice Clawson prepared a judgment of the court. So at 2187, bottom paragraph, the question, what body of directors have the legal right of representing the Banco de Bilbao, commercial entity organised under the laws prevailing in Bilbao and having its corporate home in Bilbao, must depend in the first place on the articles under which it is constituted. The interpretation of those articles and the operation of them, having regard to the general law, must be governed by the lex loci contractus, i.e., by the law from time to time prevailing at the place where the corporate home was set up. ... The question accordingly resolves itself into this: what is the government whose laws govern in such a matter the Banco de Bilbao? The answer would seem necessarily to be the laws of the government of the territory in which Bilbao is situate. Should the question arise as to what government must be recognised in this court as the government of the territory in which Bilbao is situate, the question must, in case of doubt, be resolved by a statement made by His Majesty to the court through the appropriate channel. He says the propositions so far enunciated seem to be indisputable. The only question open to argument arises from the fact that HMG recognised the Spanish Republican government with its seat in Valencia as the de jure government of the whole of Spain, entitled to be, that word repeatedly used by HMG in this case, entitled to be, but at the same time recognise the insurgent government of General Franco as the government de facto of the area in which Bilbao is situate. So far, at all events, as this court is concerned, the question seems to be settled by the principles laid down in Luther and Sager and others, which may be conveniently summarised, following Bank of Ethiopia, that the court is bound to treat the acts of the government which HMG recognises as the de facto government of the area in question as acts which cannot be impugned as the acts of a usurping government. And conversely, the court must be bound to treat the acts of a rival government claiming jurisdiction over the same area, even if the latter government be recognised by HMG as the de jure government of the area, as a mere nullity, and as matters which cannot be taken into account in any way in any of His Majesty's courts. Thus, in the courts of this country, no regard can be paid for the present purpose to the legislation enacted by the Republican government, which during the material period cannot be treated in this court as the government of the area in which Bilbao is situated. In other words, it's not open to counsel for the plaintiffs to rely in this court on the legislation on which alone their argument can be based. Banco de Bilbao is approved in a House of Lords case called Gdynia. I'll give you the reference, which is 3411, a case about the ending of recognition of the Polish government in exile. And the relevant passage is, I think, internal page 39 per Lord Oaksey. But perhaps I can show you in Carl Zeiss, bundle 2464, what is said by Lord Reid about that. And of course, the bit of Carl Zeiss which is about recognition was about the courts being in a really rather difficult position in the light of the recognition statement made by HMG and trying to find a sensible resolution. But you see Lord Reid there at the bottom of the page says it was argued the present case is analogous to cases where subjects of an existing sovereign have rebelled and have succeeded in gaining control of a part of the old sovereign's dominions.
I'm sorry, I think I must be on the wrong page.
I think 2463. Is that internal page 904?
Yes, it is. Thank you.
So the last paragraph, my lord.
Yep.
When the rebellious subjects set up a new government in opposition to the de jure sovereign, that new government does not and cannot derive any authority or right from the de jure sovereign, and our courts must regard its acts and the acts of its organs or officers as nullities until it has established and consolidated its position to such an extent as to warrant our government according de facto recognition of it. Now, this, of course, was at a time when the policy of recognition was that if you tick the boxes, you got recognised. That's the important point to appreciate. He says the case of Banco de Bilbao affords a fairly recent example of it. And he cites that, we say, clearly with approval, and he cites Luther and James, we say, clearly with approval. So those cases have the imprimatur, we say, of this court. He goes on to say the present case is essentially different. So that's fine, it's different on the facts. And then finally, to bring matters right up to date, well, I suppose right up to date is the Court of Appeal saying that all those cases are correct and applicable. But if we look back to Mahmoud and Braish, which is 2845, and the passage with which I began, it seems a very long time ago, yesterday, paragraph 43, it's well established by authority the one voice principle is engaged by recognition of foreign governments as de facto governments, and such recognition says nothing about the de jure status or constitutional lawfulness of the government under local law, and that it's de facto that matters, because recognition of a de facto government is a recognition of its sovereignty. And he then goes on to set out the cases and approves them. And then at paragraph 56, having set out the cases, it follows therefore that the recognition, so if there's a recognition of a government, which the one voice principle requires the court to respect, is not in any way concerned with the constitutional lawfulness of the recognised government. It's not concerned with the topic which has so engaged and perhaps enraged Her Majesty's government, which is the fact that in HMG's view, Mr. Maduro is illegitimately clinging on to power. Nothing to do with it. The foreign government is, by the very fact of recognition, deemed to be a sovereign government with all the consequences that entails. Now, if there isn't a recognition, you have to decide. So, my lords, we say on authority, the important question is practical power, effective sovereignty. Now, Sir James and Malone Friends for the Guaidó board seek to distinguish that trilogy of cases. And the first supposed ground of distinction are that they are cases of insurgency. And that point is argued at HMG's intervention, paragraph 71.1. Now, what do we say about that? Yes, they are. Strictly, they're one invasion and two insurgencies. So that is different from our case. And indeed, as I submitted yesterday, in some senses, it is the obverse. And we developed in our submissions a sort of taxonomy of the recognition cases. And what I suggested is that there are some cases which are identified as category A cases, where you have an existing, well-established government which is ousted either by invasion or by revolution. And that in those cases, and all three of these cases are such cases, what happens is, by dint of force, the old government is ousted. And in those cases, what you would, we suggest, expect to see is there comes a time when the new government exercises sufficient control to be regarded as, in the old days to be recognized as, but when recognition statements aren't made in that way, to be regarded as, to be found as by the court as, the effective government. And at a later stage, you might expect, and you saw in the old cases, a de jure recognition. Slightly curiously, as Lauterpacht puts it, identifying that, well, they may not have come into power in an internal constitutional sense, but there comes a point when we're going to treat them as being constitutional. That's the category A cases. Then the category B cases, as I characterize them, of which there is only one, which is this case. And category B cases are in a sense the opposite, where what is contended for is a constitutional change, a change taking legal effect, which does not take practical effect. So it's the opposite of the category A cases in that sense. And so really the question for this court, I would suggest, is that whether that is a distinction which really makes a difference. And if the answer is that we are concerned with sovereignty, it is a distinction which doesn't make a difference. Because in that trilogy of what I call category A cases, the question was not constitutional legitimacy, it was, to use Lord Legate's expression, boots on the ground. It was that mattered. And the real question must be, is there any reason why that should be different? Why you should suddenly ignore the practicalities because somebody somewhere says they ought to have been president and HMG agrees with them? And we say it shouldn't make any difference. Indeed, you might think that the traditional position is even more obvious in our case because it's a maintenance of the status quo. And because of the risk that giving effect to the claimant, the Guaidó position claimant, giving effect to his acts, you might think runs perilously close to a risk of unjustified interference in the internal affairs of a foreign sovereign state.
I'm not sure there's any difference. There are opposite cases at all, because if the constitutional power transfers to another government, and that is the constitutional government, then for the old one to cling on to power is a form of insurgency.
Well, in that case, it is indeed a distinction without a difference. And the rule must apply. I mean, that of course, is what the Guaidó board say. They say the Maduro board is insurgent. It's a funny treatment of insurgent when the same people stay there. But I entirely agree that the positions are analogous because the tension is between actual control, actual exercise of sovereignty, and the separate question of who you might think ought to be in control. You might think the Tsar ought still to be in control. You might think Haile Selassie ought still to be in control. But if he isn't, following it's essentially the position taken by international law, which is it doesn't matter how you came to be there. Following that, the courts have said it's the question of actual control that's important. The second suggested ground of distinction, which we see in HMG submissions at paragraph 71, hearing bundle reference 2157, is that in Bank of Ethiopia and Banco de Bilbao, the rival de jure governments were not present in the relevant territory. Now, that doesn't actually apply to Luther and Segor, but it is true that that is the case in Bank of Ethiopia and Banco de Bilbao, but it is surely entirely irrelevant. Indeed, it is in a sense simply a natural consequence of the fact that these were insurgency cases. And in an insurgency case, you're not likely to allow the old government to hang around, nor is the old government likely to want to hang around. But the point of the alleged distinction is that it said, oh, well, Mr. Guaido is present in Venezuela. That's different from these cases that the Maduro board is relying on, where the competing powers, the de jure government, was outside the jurisdiction. Well, we say that's a distinction without a difference. Why does it matter? Indeed, it would be highly undesirable to suggest that this was a critical feature, because it would encourage established de facto governments to remove from their jurisdiction their self-proclaimed rivals. If it were a good point of distinction, you would be encouraging Mr. Maduro to remove Mr. Guaido from the jurisdiction. It seems absurd that that should improve his position. The third proposed ground of distinction, set out in HMG submissions at paragraph 71.3, is that in these cases there was a countervailing express, or it's put strongly implied recognition, whereas in our case there is either, at best they say for me, an implied countervailing recognition, that's my case on implied recognition, or no countervailing recognition at all. Well, the problem with that point is the historical change in recognition point. Because when these cases were decided, it was the policy of HMG to afford recognition in accordance with international law principles, international law tests. HMG would recognize when those features were present, but that is no longer the case. And, I might add, in any event, Ms. Justice Clawson in the Bank of Ethiopia case, in that passage I took you to at 519, said that in any event, in the absence of recognition, actually being the government was sufficient for the trumping effect to take place. So we say that those cases are not properly distinguishable. To turn then to what you might call the high level of policy, is this a good rule? This well-established rule, is it a good rule? Touched on briefly at paragraph 66 of HMG's submissions. And HMG say, well, there's no moral or legal impetus behind the idea that de facto trumps de jure, put crudely. But we disagree. First of all, there is a very strong underpinning on grounds of predictability and avoiding chaos. And we gave some examples in our submissions, but how is anybody to do business with Venezuela when, if within the state there's one set of rules, but from the point of view of the courts here, there is to be another set of rules made by someone who has no way of enforcing them. That is a sort of Alice in Wonderland position, we would suggest. The second point taken against us is that there's no moral underpinning for this well-established approach. And we are all lawyers and we all are committed to the rule of law. And perhaps at first blush, we all feel somewhat uncomfortable with the idea that boots on the ground should be more important than constitutional propriety. However, one does have to think a little more deeply about it, because in the long run, the world is a safer place with fewer wars if states are left to resolve their own internal constitutional crises without intervention from those outside the state who wish to take sides. Supposing that Mr. Guaidó were to win, who would control what he did with this money? Not apparently the courts here, certainly not the courts of Venezuela. What would be the effect on the effective government of Venezuela? These are Venezuela's foreign currency reserves. They are needed now more than ever. The only person who could apply the fruits of this hard currency in Venezuela is President Maduro. Because Mr. Guaidó doesn't control any of the organs of the state. So the whole international and domestic law structure recognizes the principles of non-intervention, takes a pragmatic and practical approach to sovereignty, which is why I showed you right at the beginning the material about recognition of states. It's not interested in how the government came into force. It does not seek to judge political systems by which power is held, and it does not require foreign governments to be democratically in place, nor even to be lawful by their domestic law. And internal constitutional crises are generally left to the domestic institutions of a state to resolve. Law also recognizes the need for foreign sovereign states to hold assets overseas, and it extends immunities to their assets overseas if they are assets of a central bank. State Immunity Act does that for us. Now, we understand that there is a key jurisprudential challenge of international law to find the right boundary between self-determination and non-intervention, and the sort of the ability of international law to impose supranational norms and to provide remedies that command sufficient support for that to be workable. And we could spend ages looking at all the cases about human rights abuses and how the courts deal with that in a jurisdictional sense. But this case isn't about that at all. It's about a state bank, and state banks are systemically important institutions to states. Whatever their precise degree of independence, they are intrinsically tied to the state apparatus. Their internal governance auditing and management are self-evidently domestic matters, and that must extend to the appointment of individuals to their boards. And another of the really Alice in Wonderland features of this case is that Mr. Guaido's supposed appointees to the board don't go to board meetings, don't have any access to the books of the BCV, don't have any access to its internal systems and control, have no information even about its assets and liabilities. They cannot cause the BCV to do anything. And if they were to get hold of this money, the one thing this court can be certain of is that that would not be stated in that way in the internal books of the BCV. And from a domestic Venezuelan viewpoint, at least the viewpoint of the de facto government, it would be very difficult to see the consequence as anything other than an expropriation of state assets. And that is why this case does raise some really profound questions. And what you are being asked to do is, so it seems to us, unprecedented and dangerous. But the law is on our side. There are two competing claimants, in a sense. The Maduro, president of the BCV, notionally goes to the Bank of England and says, give me the gold, and so too the Guaido representative might do the same. And the question is, what should happen, to whom should the gold be given? We say the answer to that is the Maduro board representative. The Guaido board obviously say the answer to that is the Guaido board representative. Those are the binary options. Neither party contends for an intermediate position in which one might, for instance, say, well, until the constitutional crisis has been resolved, it might be better if the gold were given to neither. I'm pleased to say I'm roughly on schedule. So I was going to turn to Act of State, unless there's anything else I can assist with on either the recognition question or the crucial question of the effect of recognition. The Act of State issues might rise in different ways in this case, depending on the resolution of the first two issues, and we tried to provide a flow diagram to show how they might arise. The Court of Appeal set aside Mr. Justice Tear's determination of the Act of State issues and didn't formally put anything in their place. But they did make some, we say, pretty compelling observations on one aspect of the Act of State issues, which was the domestic unlawfulness when found by a court. So that's the sort of procedural status. The Guaido board appealed on that point, the point on which Mr. Fulton spent most of his time, and we put in a sort of contingent cross-appeal on other Act of State issues, because we were concerned that it might be said against us, well, that's what you ought to have done, rather than have it all remitted. But it does seem to us that the Act of State issues, not just the one canvassed in some detail earlier, but the others as well about extending the Act of State doctrine, are not easy. And this court doesn't have the benefit of a Court of Appeal judgment on them. And doesn't have the benefit of factual findings. And it seems to us there will need to be, at any rate, some factual findings, including on the question of control, of who is the government of Venezuela. Now, you could proceed on the assumed basis that I'm right in everything I say about the Maduro board's control. And obviously the act of state issues also engage questions about the status or propriety of the Supreme Tribunal of Justice. And so we raised, but I don't press it, the question of whether it is wise to engage with the act of state issues, number one, in a case where no facts have yet been decided, not as to foreign law, not as to control, not as to the status of the Supreme Tribunal of Justice, not of anything. And that, secondly, perhaps it is unwise to decide in limine that it might be right to ignore the rulings of the Supreme Tribunal of Justice in circumstances which might never, in fact, arise. But that is very much a matter for this court's discretion, how it wishes to proceed, and I'm not going to develop those points. We've made them in writing. The court will take its own view, and I'm going to deal both with the point which so engrossed the Court of Appeal, which is an important point, and with the other points which were live before Mr. Justice Tier, whose decision has been overturned, but which were not engaged with by the Court of Appeal. But this court might decide to deal with all of those, or just the first one, just the interesting one. They're all quite interesting, actually, but there's obviously a very interesting one in relation to domestic illegality. So I'm going to address all of them, but I'll focus mostly on the first one. Now, the first point I wanted to make is just to understand how these act of state points arise. And in our case, para 120 et sec, and that's 2099 in the bundle. And Mr. Fulton took you to this. It's really quite difficult, because this is a preclusionary rule, to get one's head round who is saying what. But I've tried to summarize it. So at 120, first of all, what we say, so assuming you're against me on recognition and the effect of recognition, so that we've got Mr. Guaidó and he is in some sense head of government, or you decide he's sufficiently president for his acts to prima facie take effect. What do we say? We say there is no transition statute. That's the first point. Secondly, there are other constitutional reasons, domestic Venezuelan constitutional reasons, why the appointments of the Special Attorney General and the Guaidó board are invalid. There's various points taken there, but I think I can take them together. Thirdly, the BCV is not a decentralized entity in any way. That's a somewhat arcane question of Venezuelan law, but that would determine whether there is any power to appoint because of the way in which the transition statute is worded. And we say for all these reasons, Mr. Guaidó's purported appointments are ineffective as a matter of Venezuelan law. Now, can I just emphasize, if you find that Mr. Guaidó say what were head of government or is to be treated as head of government, I accept that I can't then rely on STJ decisions which are premised on the fact that he isn't. But the point is that the STJ decisions are not so premised, at least on our case. And we must, for the time being, assume that to be the case, but that's some quite compelling reasons why that is so, not least that several of them precede his self-proclamation as president. So then, in response to that, the Guaidó board say, well, the appointments, both to the board and of the Special Attorney General, are executive acts of state, and therefore the preclusionary blanket, this is my paragraph 121, the preclusionary blanket of the Act of State rule is cast over them. They say they engage the second rule in Belhaj, the Executive Act rule. They say, therefore, we cannot challenge them, and that is so even though they've been declared to be ineffective. And finally, they say, even if the Maduro board can challenge the Executive Acts, we can't challenge the transition statute because of the first rule in Belhaj. And then what do we say in reply, perhaps rejoinder to that? Well, we say, first of all, the Act of State doctrine is unclear, unprincipled, and unnecessary. And if it has any role in English law, it should be strictly confined to circumstances in which it's already been applied. And as I'll show you in a minute, the majority Belhaj formulation does not bite on the facts of this case. The Guaidó board have to extend it. We say, secondly, that the purported Guaidó appointments are not acts of state for the purposes of the Act of State doctrine. Not because they're the wrong sort of act, but because they're not properly characterized as being acts of state. I need to develop that, but that is a point which derives very much from the thinking of Lord Mance on acts of state. And the third point is, if there is a second rule, and it is an act of state rule rather than a mere choice of law rule, it does not apply in this case because the relevant acts have been ruled unlawful by the STJ and or because they are unlawful. Now, those points 2 and 3, I think, are flip sides of the same coin, in a way. So those are the first three submissions, and at a high level, they're the most interesting ones. And they are the ones which are triggered by what the Court of Appeal said. And then there's a notional line to be drawn, because we get to the points which arise on my tentative cross-appeal, and they are, if there's a second rule, there are obviously some provisos, and it can apply even to a domestically unlawful act. It doesn't apply here because the relevant acts, although they take effect in Venezuela, affect assets here. So that's a territoriality point. Then we say if there's a second rule, it doesn't apply because the relevant acts are appointments to a board, and the second rule is established only in relation to executive acts affecting property. That's the nature of the beast limit on the preclusion. We say, sixthly, if insofar as it becomes necessary to consider the first rule, and I think my Lord Legate hinted at this point yesterday, that probably it's not going to turn on this point because you don't get there unless they've already failed elsewhere. But for what it's worth, if we get to the first rule and the validity of the transition statute, it was said against us and decided against us by Mr. Justice Tier that the Act of State doctrine itself ruled out an inquiry into whether the transition statute was a legislative act. And we say that's circular reasoning and must be wrong. I need to develop that briefly, but it's quite a short point. And what I put as the seventh point, which is about whether or not there's a decentralized entity, I think falls in with the others. I don't think that raises separate issues for decision. So one can see that the Guaidó board rely on Rule 1 in relation to the transition statute and rely on Rule 2 on executive acts. Nobody relies on Rule 3. So the preliminary point, of course, here there are competing appointments to the board. This is a point, not necessary to look it up, we make this point at para 211 of our case. There are competing appointments to the board. And just as we say the Guaidó board appointments are unlawful and ineffective, so too the Guaidó board say President Maduro's appointments are unlawful and effective. And we make this observation, that if the courts here cannot judge the effectiveness of the Guaidó appointments, it might be said that the same must apply to the Maduro appointments, if they are acts of state. And then one is left in a deadlock position. It's not clear to us what the answer to that might be. We would suggest that rather shows that it will be necessary to resolve these points rather than throw over them a preclusionary blanket. There are, in a sense, two clashing claims of acts of state. So can we start with Belhaj at 2204 and just see how that identifies the hurdles which the Guaidó board need to overcome. I just want to begin with the headnote. I hope that the headnote writer of Belhaj got some overtime or a bonus, because it would not be an easy task. But what he or she has said at page 965, first of all, deals with state immunity. We're just not interested in that. But at the, 2204 in the electronic bundle. But at 2, that the concept of foreign act of state as currently identified, provided that as a rule of private international law, a foreign state's legislation would normally be recognized and treated as valid insofar as it affected movable or immovable property within the foreign state's own jurisdiction. Just pausing there, that doesn't bite. This is not a case about property. Secondly, a domestic court would not normally question the validity of any sovereign act in respect of property within the foreign state's jurisdiction, at least in times of civil disorder. So that, on its face, plainly not engaged in our case, because it's not about property within the foreign state's jurisdiction. And 3, a domestic court would refrain from adjudicating on or questioning certain categories of sovereign act by a foreign state abroad, even if they occurred outside its jurisdiction. Nobody relies on Rule 3. So, if the headnote writer is correct, Belhaj and the Act of State doctrine does not bite. And if that's right, all of our domestic Venezuelan law points should proceed. So that the hurdle is quite high for my learned friends. They must demonstrate, obviously, in order to succeed, that the purported acts of appointment made by Mr. Guaidó are acts of state engaging the doctrine. That must be the absolute, just to get airborne. They must, insofar as they need to rely on the transition statute, demonstrate that the transition statute is an act of state engaging the doctrine. They must extend the act of state doctrine to cover appointments made in a foreign state to the body of to the board of a body corporate or to the post of Special Attorney General. They must persuade you that the act of state doctrine applies notwithstanding the fact that the purported and desired impact of these acts of appointment is in Threadneedle Street, within this jurisdiction. And perhaps critically and most contentiously, they must demonstrate that the act of state doctrine operates to preclude any inquiry into the lawfulness and effectiveness of an executive act or legislative act, even when it's been declared unlawful and ineffective by the courts of the foreign state. That being the key difference between Lord Sumption and Lord Hughes. So we submit you should be very cautious indeed about extending the act of state doctrine. We don't need to say there is no act of state doctrine. and we say nothing against or about Rule 3, the Butty's or Butty's gas bit of the doctrine. But we do say it's not wise to extend doctrines which it is difficult or impossible coherently to state, or doctrines which it is difficult or impossible to find a coherent public policy justification for. And we do say that one can properly be as rude as that about the foreign act of state doctrine. It is self-evidently a conflation of some very different rules. We've referred you to what Professor Mann said about it, and I'm sure that the court will all have read that from time to time. I don't want to spend a lot of time developing these points because in the academic literature they are already very well developed. But perhaps one can summarise. It is still not really clear how you decide what is an act of state. I think that's a bit of a weakness in a doctrine like this. And as the law presently stands, executive acts can be, legislative acts can be, but judicial acts can never be. That's what UKOS says. Now, we would suggest there's no clear rationale behind that, and it causes problems. And it causes problems because executive and legislative acts can contradict one another, and either or both of them can contradict judicial acts. As pointed out in Belhaj, even on the very restricted rules stated in Belhaj, Rule 1 and Rule 2 could be in conflict. And how are you to resolve that? Now, my tell was tweaked a little bit by saying, oh, well, we haven't said UKOS should be overruled and judicial acts elevated up to make a triumvirate of acts of state. But we don't say that, that's right. Because that would make the doctrine even worse. Because you have three competing things which you weren't allowed to look into at all.
Well, we haven't been taken to UKOS, but I don't read it as saying that judicial acts are on a lower level, only that one can, there's a broader concept, if you like, a public policy, which will allow you not to take them at face value. One can look into the justice of the proceedings, which allows you to intervene more readily with a judicial act than you can with an executive or legislative act, and that is the sense with which I read the Court of Appeal as saying that foreign act of state doctrine doesn't apply to judicial acts, because for executive and legislative acts there's only a narrow public policy exception, whereas for judicial acts there's a broader exception that if the court isn't a just court, you won't recognise its acts.
Well,
it's crudely stated,
yes,
but that's
I
roughly
understand,
what it says.
I understand the point perfectly. I suppose you could analyse it in that way, although I think more traditionally the way it is put, and in a sense the way in which it is put in Belhaj, is it is no part of the act of state doctrine that there is a preclusion preventing you from looking at, from querying foreign judicial acts. It just hasn't got in. Now, it may come down to the same thing. There would be different ways of achieving the same result. So I accept what you say, Lord Mayor. Just before I move off the general observations on act of state, we do submit that it is not necessary for a sensibly functioning legal system, and it seems that it has in effect been rejected in Australia by the case of Motti, and rejected in Canada recently by the case of Nevson. And we adopt the Professor Mann observation that neither Rule 1 nor Rule 2 has any compelling logic to it, why should the fact that an issue of domestic lawfulness is in issue in proceedings in England, foreign domestic lawfulness is in issue in proceedings in England, mean that it cannot be decided when it would have been decided if it could have been raised in the foreign state? It's not easy to see any reason of principle in the modern world behind Rules 1 and Rule 2. But I'm not going to try to develop that full frontal attack because in a sense it, I'm sure, will be familiar and the academic writers make it much better than I can. So I can turn to the second submission, which is the submission in our case at paragraph 171. And this is what I described as the Lord Mance point. And it takes off from the observation, which must be true, that the acts relied on by Mr. Guaidó must be treated as acts of state if they are to engage the doctrine. And if it isn't too cheap a point, it is perhaps worth noting that the doctrine is foreign act of state doctrine. It is not a foreign sovereign act or foreign head of state doctrine. It is act of state. And so we say that fundamental to underpinning such bits of the rule as have any proper justification at all is that the act in question is properly attributed to the foreign state. And can I remind you of what Lord Mance says in Belhadge at his paragraph 65, page 2325. He's dealing at paragraph 65 with the second type of foreign act of state. He says it has direct support at Court of Appeal level, and that's Princess Paley Olga, which we'll look at later. But other support for it in English law is noticeably limited, and it is, in my opinion, unnecessary on this appeal for this court to reach or endorse a conclusion that it exists in any form at all. And Dicey and Morris, as he points out, makes no reference to it. He then goes on to say at F, the commentary to Rule 3 in Dicey and Morris approves a suggestion made by Lord Keith in Government of India and Taylor that enforcement of claims of the sort identified would amount to an extension of the sovereign power which imposed the taxes or law or as an assertion of sovereign authority by one state within the territory of another. On that basis, Sub-Rule 2 may be seen inversely as a recognition of the sovereign authority of a foreign state within its own foreign jurisdiction. But a potential problem about such a reading is that it equates sovereignty with executive activity. In states subject to the rule of law, a state's sovereignty may be manifest through its legislative, executive, or judicial branches acting within their respective spheres. Any excess of executive power will or may be expected to be corrected by the judicial arm. A rule of recognition which treats any executive act by the government of a foreign state as valid, irrespective of its legality under the law of the foreign state, and logically it would seem irrespective of whether the seize was being challenged before the domestic courts of the state in question, could mean ignoring rather than giving effect to the way in which a state's sovereignty is expressed. It says the position is different in successful revolutionary or totalitarian situations where the acts in question will in practice never be challenged. And it's probably unsurprising the cases relied upon as showing the second kind of foreign act are typically concerned with revolutionary situations. So and the Court of Appeal in our case were very taken with that observation. I think they said it contained an important insight And it does, and we would suggest it provides one possible answer to the conundrum of how on earth can it be right that we ignore the findings of overseas courts, because perhaps one would say what is properly to be treated here as the act of the foreign state, taking into account its judicial pronouncements, the purported act, the purported legislation. So I gave some examples, I think some of which my lords put to Mr. Fulton, which tease out the difficulty here. What of, and this is my paragraph 178, what of a USA legislative act which has in fact been struck down as unconstitutional by the US Supreme Court?
Can I just ask about that? I mean, that would be the contrast Lord Mance draws is between a state subject to the rule of law on the one hand and a successful revolutionary or totalitarian situation on the other hand. And the example of the United States Supreme Court is evidently of a state subject to the rule of law. As I understand it, the constitutional crisis in Venezuela extends to the STJ as well as the presidency and the National Assembly. There are rival STJs, for example, and disputes about the validity of appointment of each.
I don't think we certainly haven't had any evidence in these proceedings about a rival STJ, nor has the idea of a rival STJ been relied on by the Guaidó board. Whether or not there is in Washington a group of people who sit down and say they're the Supreme Tribunal of Justice of Venezuela, I actually don't know. But it may be that ultimately, when some facts are finally decided in this case, some of those questions will arise. But the Guaidó board have chosen to come on preliminary issues, and in the traditional way, therefore, the facts must, we say, be assumed against them. And on that assumption, Venezuela is a functioning democracy with the rule of law intact and operational.
I see. Some of us may remember the helicopter gunship attack on the STJ, but you want us to proceed on the basis that it's a situation analogous to the US Supreme Court.
Yes, in its structure, yes, it is, because its structure is analogous. Because under the Constitution, the STJ has power to, it does have power to strike down legislation that does have the sort of classic Supreme Court powers. And certainly with respect, this court, particularly when the facts have not been found, cannot proceed certainly on any other assumed basis than that.
I was just wanting to clarify
the
point.
And then
taking your US example, one might think there is a difference between a case where the US court has ruled and a case where it hasn't. And suppose an executive order of the president sought to be relied on in this jurisdiction, and it's argued that it's in fact unconstitutional. It might be thought fairly invidious for the UK courts to embark on deciding that in circumstances where that hasn't been argued in the United States. On the other hand, it might be thought different if there is a ruling of the United States court which declares it unconstitutional.
My Lord, I entirely agree. The example is much, much stronger if there's been a ruling. But what if the ruling is tomorrow and the court here is being asked to decide? You know, like all these things, there's going to be a...
Well, then the court might adjourn, but if it doesn't do that, it would seem appropriate to not to take on itself the job of deciding what the position is under US law.
Well, in a sense, a fortiori inappropriate, because you know it's going to be decided in the foreign jurisdiction. It makes it actually even more inappropriate to do it, because all you need to do is wait. But the problem is, or potential problem is, if there is a challenge which for some reason can't be raised there. But the example, it seems to us, is a good one. It's obviously much stronger if there's been a ruling than if there isn't. Of course, I accept that. The second example, and again this is sort of putting up a mirror, suppose that in foreign state S, the head of government has purported to prorogue the Legislative Assembly. But the courts of S have ruled the prorogation unlawful. Is the prorogation, although ineffective in state S, to be regarded by the English courts as an act of state S? Well, we would suggest surely not. And this court might have particular views on that question. But if in the foreign court which was dealing with this question they took the same view as is urged on you by the Guaidó board, the courts would be saying, the executive act cannot be impeached. The fact that the Supreme Court in that country has said it's ineffective is neither here nor there. That's an unattractive doctrine, we would respectfully suggest, quite apart from anything else, lead to complete chaos.
You don't have to take it to those sort of cases. It could be any judicial review case in which an executive act has been found to be outside the powers of the minister.
Exactly. Exactly. These are in a way the nuclear options, but the point remains the same. And so we say this is all grist to the mill about being very careful in deciding what it is you treat as an act of state in the first place. And you should not be treating as an act of state, or at least you should not in general be treating as an act of state, an act which the domestic courts who have authority over it have said is ineffective. And perhaps one can really tease it out, as I've tried to do at paragraph 182 of my submissions, electronic bundle 2118. Yes, electronic bundle 2118. My paragraph 182, the Guaidó board's case says that their success on grounds 1 and 2 means that interim President Guaidó's appointments of public officials are the acts of the Venezuelan state. Well, for the reasons I've just explained, we don't accept that. You might, if you're against me on recognition, decide that they are acts of the president, qua head of state, but we say it does not follow from that they are to be treated as acts of the Venezuelan state. If you're interested in sovereign immunity, and the question is it an act by the sovereign, they would be home, but you're not. You're interested in whether they're acts of state. And we submit at paragraph 184 that none of what we have said conflicts with any of the possible rationales of the act of state doctrine, i.e. the idea that you should look carefully to see whether something is an act of state. If the rationale of the doctrine is respect for the autonomy of the foreign state, that respect is not undermined if the English court applies the foreign law as declared domestically. If the rationale of the act of state doctrine is competence of the English court, that's unproblematic if the foreign court has rule, or we would say will rule. If the rationale beneath act of state is promotion of certainty, well, one can hardly imagine a more disruptive event than the English court coming to the diametrically opposite conclusion. So we say that our suggested approach is consistent with comity principles as traditionally understood. And we do say, paragraph 186, that the result, the approach for which Mr. Fulton was arguing is startling, and it does place Mr. Guaidó above the law. And that is contrary to the rule of law. Sir James yesterday said, well, the rule of law is a flexible beast, and you don't want too easily to start throwing about the idea that things are contrary to the rule of law. But perhaps the rule of law which it is contrary to is, be ye ever so high, you are not above the law. Thomas Fuller. Because the result for which Mr. Guaidó, who has a constitutional claim, he says, to be president, is that he is not properly subject either to the Venezuelan courts or to the jurisdiction of this court, nor apparently to any other. And that is truly startling. Now, that first submission is one suggested answer to this conundrum. The more direct answer is my second submission, which starts at paragraph 188, which is that if there is a second rule, the rule about executive acts, a second rule of general extension, it doesn't apply because the relevant acts have been ruled unlawful by the STJ, and or we say because they are unlawful.
To Lord Sumption's,
An exception to the expansive or to the Sumption formulation, exactly. And that in itself.
Well, I don't think Lord Sumption being an exception to if it was said in fact unlawful, but I haven't found in Lord Sumption anything addressing a situation where the courts have ruled on the point.
Nothing expressed, no. But I mean, he doesn't consider it because his formulation is it doesn't matter. I mean okay, I'm careful not to argue Mr. Fulton's position, but that's what Mr. Fulton says. If unlawfulness doesn't matter, it doesn't matter if it's said to be unlawful. He says that must follow. And one way to deal with that would be to make an exception limited to an actual declaration of unlawfulness. That would be plainly one way to deal with it. But can I take the logically prior point, which is actually, does the Act of State doctrine preclude looking at lawfulness at all? And that's got to be the first stage before we get to any exceptions. And both HMG and my learned friends say that Lord Sumption's approach is right and should be preferred to the other 5 members of the court who didn't agree with it. But it seems to us they don't really develop reasons why. So what I wanted to do is deal with the two cases which seem to us to be the key cases in Lord Sumption's analysis, which I think it is fair to say are Princess Paley Olga and the Duke of Brunswick. It's a more recent one, Princess Paley Olga, and a much older case, the Duke of Brunswick. So what I'm going to try to do before the short adjournment is deal with those two cases. I might get a little bit further, actually. So Princess Paley Olga is bundle 2856. and it's another Russian expropriation case. And the chronology is quite important, but also a little obscure. There was a recognition, it seems, of the Soviet government as de facto government in late 1917 or perhaps 1918. That is internal page 722, bundle page 2860. Although, and this is why I said it's a little obscure, Lord Justice Sankey at 287, bottom of the page, says it was recognised de facto in March 1921. But in any event, in the first half of 1918, reference internal page 726, artwork was taken to a museum by persons whose acts were adopted by the Russian government. So that is the expropriation in the first half of 1918. In 1920, there was a decree nationalising property of all those who had fled Russia. In March 1923, there was a decree nationalising everything in museums. And in 1924, there was recognition de jure. Needless to say, Princess Paley, whose artworks had been taken first to a museum and then taken away from her, and was complaining about that, had various arguments to say that no effect should be given to any of this in the English courts. And there were 3 points. Ground one, we see from Lord Justice Scrutton, that's internal 722, bundle 2860. He says they, the first point is that by the decree of March the 18th, 1923, was a decree authorising works of art, antiquities, to be part of the museum fund and being safeguarded, to be recognised as state property. And he says he's quite satisfied on the evidence that that was the case. So the first ground is the 1918 decree. Over the page at 723, the second title in the Russian government alleged by the defendants, in other words, the other way it's put, bundle 2861, is that under section 1 of decree number 111, signed by Lenin, the property of the Russian Soviet Federal Socialist Republic, all the movable property of citizens fled outside the confines of the Republic. So if you left, which I suppose you might have done in these circumstances, if you fled, your property was expropriated. And it says it's clear on the evidence and admitted by the princess that she escaped from Russia without a passport. I'm satisfied that's fleeing from Russia within the meaning of the decree, so he construes and applies the overseas legislation. And he says that's right. And then the point which is said to establish a wider ambit of the Act of State rule is the third point, and it's the bottom of 2861. Lord Justice Scrutton says, there is, however, a third defence which the judge at first instance rejected, which I think should also succeed. Counsel for the defendant put it in the front of his argument below and before us that if the seizure of this property began without legal justification or only by revolutionary right, it was ultimately adopted by a government which was recognised by the British government as the lawful government of the territory in which the property was, and that this was an act of state into the validity of which this court would not inquire. And we would suggest certainly that language looks like Act of State preclusionary rule language. We could quite accept that, and one can quite see why this is sometimes, indeed often said, to be an act of state case. But I said earlier that the courts at this stage were quite agitated by the retrospectivity, the retrospective effect of recognition. And we would respectfully suggest that in truth, the focus of this case is a question of the impact, the retrospective impact of recognition, in the sense that that can make lawful something which otherwise would not have been. And if that's what this case is about, it's not really about act of state preclusion at all. It's just about what is or isn't unlawful under the domestic scheme. And it does seem to us that that is at the very least an available analysis and proper reading of this case. In other words, the question is not, we can't look at what happened at the early stage because it's foreign, but was it rendered lawful retrospectively, even if it was unlawful when it happened? Was it domestically rendered lawful by the retrospectivity or retroactivity of recognition? And if you see the way Lord Justice Scrutton deals with it, he cites at 2863 Urchin, the American case, which plainly is an act of state case. But what he cites from it is this: it's also, and this is the top of 725 internal, top of 2863 electronic, it's also the result of the interpretation by this court of the principles of international law, that when a government which originates in revolution or revolt is recognized by the political department of our government as the de jure government of the country in which it's established, such recognition is retroactive in effect and validates all the actions and conduct of the government so recognized from the commencement of its existence. And then he says, to these principles we must add that every foreign sovereign state is bound to respect the independence of every other foreign sovereign state, and the courts may not sit in judgment. Now, very familiar material. Two further authorities, he says, of the Supreme Court of the United States are cited in support of that. This court acted on the principles laid down in the above cases in Luther and Sagel. For this reason also, in my opinion, the claim of the plaintiff fails. And Lord Justice Sankey, at internal 728 to 729,
may well be explicable on the principle of the application of the lex situs. But in this passage we have a quotation from Chief Justice Fuller in Underhill and Hernandez, which is the classical statement of what we're referring to as Belhadge 2.
I entirely accept that. I entirely accept that. And that is why this case has been read as properly an act of state case. I completely agree. But it does seem to us that if you look at what the judges actually decided and what they were focusing on, it was the retrospective effect of recognition. And if the retroactivity of recognition, so the argument was, really, three things happened. You took my paintings and then they were in the museum and then I fled. And the argument was the earliest of them was unlawful under the foreign law concerned, because it's pre-recognition. And there are two possible responses to that argument. One is, it doesn't matter if it's unlawful because of the foreign act of state doctrine. That would be one way to knock out the earliest complaint. The other way to knock out the earliest complaint would be, well, you say the first one was unlawful by the domestic law, but it isn't, because the retrospective effect of recognition is to make it, in our eyes, lawful under the Russian domestic law.
Does it make it lawful under Russian domestic law, or does it simply extend the protection of the Act of State principle to those earlier acts?
Well, the way in which it's put at the top of 725 is in what he's citing is the recognition is retroactive in effect and validates all the actions and conduct of the government so recognized from the commencement of its existence.
Indeed, making those acts of state. The principle is that once it's recognized, then its acts are regarded as sovereign acts from the date at which it first established itself as government.
Yes, I understand that. Yes, I think I understand that. But if you were to ask, why is it that I cannot make a complaint of domestic unlawfulness of the earlier act, you might be given one of two answers. One is, you can never make a complaint of unlawfulness of foreign acts of state. That might be one answer, which would be the Act of State preclusionary rule. But the other answer might be, well, you can't, in this case, make a complaint of unlawfulness because it's not unlawful, because it is an act of the government. Your complaint of unlawfulness was that it wasn't done by the government.
Done by the government doesn't, it's a factor, make it lawful. I mean, just the fact that the revolutionary government seized the property isn't enough, is it? You've either got to find that that was a lawful seizure by the government, or it doesn't matter whether it was lawful.
You have, but perhaps the thinking is that there's, in a sense, a presumption of legality. There's a presumption of legality that's not available when the act is not done by the government.
Well, that's one way of formulating an act of state doctrine. Presumption, well, if you like, of legality, or you can say one can't consider its lawfulness. It comes to the same thing, really.
Well, Lord, I'm not sure it does, because if there's a presumption of legality caused by the retrospectivity, that means you're going to have to find something which actually makes it domestically unlawful to get over that presumption. Whereas if it's a blanket preclusion, that would take effect differently.
Acknowledging that it was an act of a government makes it lawful by the local law.
It doesn't, and I don't go that far. But what I do say is there is a world of difference between an act not done in the exercise of any sovereign power, so not done by the government, because there's no retroactivity, and something which it turns out is done by the government, where surely you would have to assert and prove some particular ground of unlawfulness. That is to say, that government did not have power to do X.
As I read this passage, Lord Justice Scruton is saying it is to be taken as a governmental act because it was an act after the government, that the Soviet first established itself as a government. And that provides the answer to the problem. It's a governmental act. We can't look into it.
Well, my lord, I accept that is a reading of it. I can quite see that, and I do recognise that there is reference to act of state. But the tipping point, the answer, seems to have come from the retroactivity of recognition, in a sense, alone. And we would suggest that in those circumstances, in the absence of any ground, any freestanding ground to say it's unlawful, that, in other words, if it is an act done with prima facie done with governmental authority, you're going to have to come up with something better to get an unlawfulness argument off the ground. I think that's the...
See that surely it's for the person who's has the property to show they've got a good title to it. And that's why the first two grounds are important, because those were Russian laws under which title passed.
Well, I think that again would, in a sense, depend on presumptions, you know, what your natural starting point was, on whom the burden might lie. Can I deal with Duke of Brunswick? Much older case. 3335. I'm sorry, I perhaps should have said in relation to Princess Paley that it is, perhaps I did say it, I don't know, it's not on any view a case in which there is a foreign court's finding of illegality. And that's I think obvious.
Sorry, I didn't hear that.
It's not a case where there was a foreign court's finding of illegality.
Yes.
It doesn't deal with the strong position. So then, Duke of Brunswick, Mann references 6064, said it's a sovereign immunity case. We would suggest that one has to be careful about cases, particularly cases involving sovereigns, decided at a time when it is probably, I think, fair to say that the essential attitude would be that a sovereign can do no wrong, or can really do no wrong, the very strong powers of the sovereign. So we say it is at least primarily a sovereign immunity case. And the real question is, does it go any further and establish any part of the act of state doctrine? That must be the point.
It's clearly explicable on principles of state immunity.
Yes.
But Lord Campbell, I think, went further and said that the Duke of Cambridge would have been able to raise the same plea.
Yes, he did.
Even though he wasn't a sovereign.
And that is it is that statement by one of the five members of the court which is potentially opens this up as an act of state case. I respectfully agree. So the first point is it is really only one of the judgments, which makes it explicit, I think, that it's being treated in that way. It is a case in which only one side was argued, but I wanted to go at the bottom of 3340 to the argument that was put by the respondents, who weren't called on, because we see here set out their printed case. I don't know whether it's all of it, but if it is, there were shorter printed cases than I'm afraid we burdened you with. And the points taken were, first, because the respondent, being an independent sovereign prince, is not liable to be sued in any court in this country. That's obviously an immunity point. Second, because the immunity of the respondent from suit as an independent sovereign prince cannot be affected by his being a subject of Her Majesty, ... and that, we would suggest, still is plainly an immunity point. Third, because the immunity or exemption of a foreign independent sovereign prince from being sued cannot be less than that of an ambassador, that is obviously an immunity point. Fourth, because it appears by the bill that the matters therein complained of are not the subject of municipal jurisdiction, being either matters of state or political transactions, which cannot be dealt with in the courts of this country. And fifth, because the maintenance of this suit is inconsistent with principles of public policy. And the reason why I took you to that is that I submit that if and insofar as this is an act of state case, one can see from the fourth and fifth submissions that if only Mr. Turner and Mr. Elmsley had had a time machine, they would have been making an act of state Rule 3 submission. And that perhaps is not surprising because of who these dealings were between. So, really the points are short on this. First of all, we say it's an old case and one should be a little bit careful with it. Secondly, that it is only one of their lordships who says anything which clearly can be treated as going beyond sovereign immunity. It is put quite lightly. It's at 3344, 3344. I think the learned gentlemen who've argued this case with very neat ability were rather sanguine in almost assuming it as a postulate that the Duke of Cambridge might have been sued for this matter, my Lord Jones's point. I have most serious doubts upon that point, because even if he had been sued, it would equally have been a matter of state. The same questions would have been submitted to the Court of Chancery, namely whether the King blah, 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 blah. So it's put quite diffidently. It's only put by one of their lordships, and again, we would suggest that if this is support for anything, it's support for the Butties Gas line of act of state cases. But Lord Sumption deals with it on a wider basis and treats it as going more generally to act of state. If that is a convenient moment, I've dealt with those two cases which I was hoping I would do before the adjournment.
Yes, certainly. Well, we'll adjourn now and resume at 2 o'clock.